of the Board of Ethics to order. In the interest of public health and safety and pursuant to the Governor's Executive Order and TAC 29, TAC 20, members of the Board of Ethics and staff are participating in this meeting by teleconference. In accordance with the Executive Order, the public may view this meeting online, but not in Executive Conference Room 103. The city launched a virtual commenting portal, e-comment, that allows residents to comment and participate in the meeting from their own homes. And the link is chulavistaca.gov/virtual meetings. Your comments must be received before I call for close of the commenting period in order to be considered. After the commenting period is closed, I will announce a brief pause to allow the commissioners time to read any comments that have been received. If you have any difficulty or need assistance with e-comment during the meeting, please call 619-576-5366 and the city attorney staff will assist you. Would the secretary please call the roll?
You're muted.
Oops, my apologies. Chair Guerrero.
Present.
Member Barragan.
Present.
Member Chin.
Present.
Member Salzman. We'll note the record as Member Salzman being absent. Member Teal.
Present.
Member Torres.
Present.
Member Welling.
Present.
Okay, thank you. All right. Public comments is a section on the agenda for members of the public to address the board on items that are not listed on the agenda. I will now call for a 2-minute pause to allow the public to submit any final public comments. Board members, as a reminder, please refresh the view on your screen to ensure new comments appear. Please display the 2-minute timer. Okay, the commenting period for public comments is now closed. Were there any comments submitted? I don't see any in the chat. I'm sorry.
No comments received.
Right, thank you.
You're welcome.
So before we begin the first agenda item, I'd like to welcome everybody back. I know I started kind of right off the bat there, but welcome back everyone. I know it's been a few months, and thank you, Simone, for putting this together. So hopefully everybody's been healthy and safe, but we've been a few months without together. This is good that we catch up in the month of the new year, right? So we'll go ahead and get started with the first agenda item. It's an update on and report on the interview process for the new appointment of the Board of Ethics members. And I believe you have a presentation, Simone?
Yes, I do. I just briefly wanted to let you know how the process went and that a selection was made. Basically, we had a panel that consisted of a Board of Ethics member, Commissioner Teal or Member Teal was part of it, as well as Todd Glassman from the Charter Review Commission. They had two meetings. The first meeting was kind of organizational in nature, where they went over the applications. They decided who they would like to interview from the applications, and then went through and looked at interview questions that would be asked of all applicants, and then organized kind of how they would do the interviews themselves. The second meeting was the actual interview for the applicants. There were, I think, about up to 10 applicants in the pool. There was one position that was available. They decided to interview all 10 applicants. However, through the process, I think about 5 to 7 actually interviewed. The others elected not to. And so after the interviews, there was quite a number of people that were well qualified, that had a lot of experience and brought different perspectives. At the end of the day, they ended up choosing Mr. Mario Salzman. And he brings a good amount of experience. He had prior work with the United Nations and did stuff in other countries, and was able to see how and this was part of his discussion, how corruption statutes and corruption was dealt with in the other countries, and he had an interest based on that experience. When his resume was looked at, it was pretty impressive, with a lot of experience that would be helpful to the commission. He isn't available today. It's my understanding in part that he has some questions on the Form 700 that he wants to complete properly. So I'm working with him on that, as recently as sending him an email today, working with the city clerk's office. So hopefully we'll have him in the next meeting. You'll get a chance to meet with him, and he could expand on his experience, and he looks forward to working with everybody. So the process, I think, ran smoothly and efficiently, and we have a good member that's coming on board. So with his slot, we are a fully staffed commission, and pretty much it's a group that you folks will be working together probably with the next 3 to 4 years, with no new members coming on board, because I think everybody still has a good amount of time left. So we won't have to do this for a while. So I want to thank Commissioner Teal for her participation. It was a lot of good insight and discussion in the selection process. Commissioner Teal, would you like to say anything?
I got to have a nice debate about our choice, and so I enjoyed that, and it was respectful. So we had a lot of good candidates, but the one that won out had a lot more on the resume that was probably a perfect fit for us when he gets to be here.
Definitely. So that's pretty much it. So hopefully by the next meeting, we'll have everybody on board, but we are a fully staffed commission for the purposes of staffing it. This item does not require any action. So I know on the script, there's a section that talks about actions and things like that, or motions. We don't have to do that. In fact, when you look at the agenda, the only item which would actually require a formal motion is the last item on the agenda. So unless you folks have a motion to make on the 2 presentations that are coming, you could forego that part. However, we do need to do the 2-minute public comment on this item and other items as well. So I have nothing to add. Thank you, Mr. Guerrero and Stephanie.
Thank you, Simone. Thank you, Ms. Teal, for doing that during this time. Really appreciate you guys taking the time to do that and getting us fully staffed. So now I'll open up to the board members. Have any clarifying questions for staff before we move to public comment? Okay, nothing heard. I will now call for a 2-minute pause to submit any final comments on the item before the board. As a reminder, please refresh your view on your screen to ensure any new comments will appear. Please start the 2-minute. Thank you. Okay, commenting period is, for this item, is now closed. Were there any questions submitted?
No comments were received.
Okay. Do any board members have any comments or questions before we move on? Okay, the next item on the agenda is presentation discussion on the Code of Ethics and duties of the Board of Ethics. Simone, you have a presentation? You're muted.
I do have a presentation. I need to have the me put on as a presenter if Melanie can confirm that. Okay, I'm now a presenter, so I'll do the PowerPoint real quick. So can everybody hear me? Hello?
Here.
Okay, loud and clear. Okay, good. Go back to the PowerPoint. So this really is kind of a part of what I said I'd like to do at our meetings at a minimum. This is part of the discussion on getting you information and training on different kinds of ethical rules that are out there, rules and laws. This is kind of the first one, which is basically the rules that you folks operate under. It's the Board of Ethics procedures, as well as your role both under Chula Vista Municipal Code Section 2.01, which is the Code of Ethics, as well as 2.28, which is the Board of Ethics. And then also some just brief kind of ground rules in terms of how you folks conduct the meetings and things like that. So I'll probably start off with that. The second PowerPoint presentation I have, which is the next item, talks about a proposed lobbying ordinance. The goal was in these trainings was to try to keep it somewhat short, around 20 minutes per. That way we get enough general knowledge where we can ask questions and develop it as we need it as we go forward. And so for today, what I'm going to talk about in the Board of Ethics duties, just the general kind of meeting format and things like that. And then the board duties under 2.01 and 2.28. It says Brown Act and Public Records Act. Those will be topics that we'll cover at later meetings. So basically, in terms of meetings, our meetings are every third Wednesday of the month at 5:15. So that's our regular meeting. We are able to call special meetings at different times. All we have to do is provide 24 hours notice. However, the goal is, if we do have a special meeting, is that we try to give as much notice as we can. So if we don't have to do 24 hours, the preference is to do the full 72 hours that we would in a regular meeting, even though 24 is the minimum requirement. If you're going to be absent, there's an email there that's listed to basically let us know that you're going to be absent. That way we're able to know whether we have a quorum or not. If we don't have a quorum, we're able to cancel the meeting and save everybody time. In terms of absences, if you miss 3 consecutive unexcused absences from a regular meeting, then the position's deemed vacated. However, what's possible is we can excuse those unexcused absences down the line. So say, for example, you missed 3 regular meetings, and these aren't special meetings, these are regular meetings that you're absent from, but we hadn't addressed your absences. We're able to address them and see if there's good cause in terms of excusing the absences. Generally, under the municipal code, there's just specified reasons as to when you could beat absences. That includes illness, business commitments, pre-planned vacation with notice, a funeral or religious services, unscheduled emergency, any other reason where 7 days notice is provided. So those are pretty much the reasons that we have. We do have a formal notice that's used by other boards and commissions. I could ask the city clerk to provide it to us so we can give to you to complete that. We have a good record of it. The other thing is when we're voting on absences, like the agenda, individuals can vote on excusing their own absence as well. So there's no conflict of interest, particularly since there's no monetary interest involved. So we're able to do that. And then we'll note the absence in the record to make sure that it's reflected that it was excused. Again, the big deal is making sure that you have no more than 3 unexcused absences in a row, those need to be addressed, or else the position will be deemed vacated in terms of that.
Simone, I'm sorry
Yes.
to interrupt. Are you intending for the board members to be able to see your PowerPoint? Because we cannot.
Oh, because it's on my screen.
Did you share your screen?
Let me see.
My apologies for interrupting.
No, that's
There we go. Perfect.
okay. That's what I did. So basically, these are the topics that we're going to cover. Like I said, the absences, agenda, minutes, conflict of interest, communications, and recommendations to council, and then the duties. Here is the meeting schedule that I just discussed and the absences. The next thing is the agenda. The agenda is actually a critical document because under the Brown Act, we could only do business that's listed on the agenda. So if it's not on the agenda, it's not an item you could realistically discuss or take action on. So it's important that we follow that. So the agenda provides the roadmap that will be covered in a meeting. It must be posted either 72 hours before the meeting, that's for a regular meeting, 24 hours prior to a special meeting. That's the rule, but we try to give as much notice as we can on the special meeting if possible. There are exceptions to the normal requirement that it has to be on agenda, but those are pretty much emergency type situations that are very specific. If we ever had to do that, it's something we would review the Brown Act for and advise on. It's generally not done for a board and commission. I have seen it done at city council, particularly in light of COVID. But again, it was based on the Brown Act exceptions that are there. And just, the Brown Act is the act that governs public meetings. Only items placed on the agenda may be discussed or acted upon. It's not unusual, for example, in public comments for somebody to come up and say, I have this problem and you folks want to discuss it. In the public comments, the way we advise city council and all the boards and commissions, if somebody comes up to a public comment and wants action on something that isn't on the agenda, you folks can make a referral for us to put it on a next meeting agenda, even with the recommendation that be a special meeting if it's time sensitive and you folks deem it. So there is a way to get something on the agenda if the public wants, alerts you to something you folks would want to do. In terms of how to formally place things on the agenda, the chair may place things on the agenda, our office may place things on the agenda, and then individual members can ask that have things placed on the agenda by vote of the majority members. So realistically, you can contact the chair if you want to put something on the agenda. You can contact us. However, we will defer to the chair. So if one of you folks call us and say, hey, can you put this on the agenda? We will ask you to call the chair and have the chair put it on. If the chair says no, then our advice would be that it get put on the agenda for voting to put it on the agenda. That way there's a majority of members to put it on there. So it could either be done by the chair, by our office, or by vote of the majority of the members of the agenda to place something formally on the agenda. The agendas must provide for public participation, meaning they get to provide public comments as follows. Usually it's 5 minutes on an item for an agenda and 3 minutes public comment section. For items on the agenda, it's important to note that the public gets to comment before you take any final action. So the 2-minute pause should be done. For example, I put on a presentation, there's a motion on the table, and then the public gets to comment before you make your final vote. If there is no motion made or motion required, it gets put on after the staff presentation. That way the public can either comment on what I said or alert you to something else they had a concern on. But the key thing is to allow the public to have a meaningful participation in the meetings. There's a couple of things that potentially can happen when the public speaks. The public has a First Amendment right to speak, and so the language that they use can be hurtful and insulting at times, and can even be profane. That is allowed to some extent, meaning that so long as it doesn't disrupt the proceedings, they are allowed to be critical. In fact, the Brown Act itself says that the public has the right to be critical in public meetings. So The only time we really would excuse somebody or not allow somebody to participate is if they become threatening in their conduct. But they can call people names, be critical of a decision, and things like that. So there's a lot of leeway. They're able to record the meeting on their own and have their own cameras or recording devices at the meeting. Again, we want the public to participate. We're respectful of their First Amendment rights. Again, but they can't cross the line and become disruptive or threatening to individuals. And there's a process that we follow on that. Again, the public gets to participate before we make any final decisions on that. Let me go back. Okay. In terms of the agenda, how you conduct yourselves, we don't have any formalized rules of order. We generally follow informally the Roberts Rules of Order, where somebody makes a motion, it gets seconded. There's also a procedure during that somebody can call for a vote on different things. Usually we haven't had to use it in these meetings, particularly since we try to treat each other respect and care for each other in terms of listening to everybody's opinion. So we really haven't had to, but I think at a minimum, again, it's a motion and a second, some discussion on it, and then a call for a vote. That's generally what we have done in the process. Other boards and commissions, if the discussion does get more heated and there's a breakdown in the communication in that process, we would go towards the Roberts Rules of Order and strictly enforce that, particularly in terms of time limits on discussion. But I think overall, while there's been heated discussions in the Board of Ethics, it hasn't required any formal rules on that. The minutes that we use, they're actually action minutes. All we're really required to record is the action that's taken. So we don't record the discussion or document the discussion that goes on for each particular item. And so we do put what action was taken on by the board. So it was a 5-0 vote or 7-0 vote to do this. The other thing we are, however, required to put on is whether the public speaks and whether they were for or against the subject. So our action meetings will show what was done and then whether the public, whether they were for or against an item. So it'd be 4 people, the public spoke, 3 of which were against, 1 was for. So that's how we record it. There's also another thing. A lot of times when speakers do speak, they are given a speaker slip and they fill out their name and where they live and things like that. There is no requirement that they do that. It's done more of a courtesy. That way we can call their name and know where they're from. But if somebody says, I don't want to give you my name and I don't want to tell you where I live, I just want to say something, under the Brown Act, they're not required to do that. They're not required to provide that information for us, and they would be allowed to speak. Again, we record our meetings. We're doing it right now via the WebEx, so we're recording that, and it gets placed on the website. The other thing on the minutes, you can vote to approve the meetings even if you're not present at the meeting that's covered by the minutes. Again, a lot of times that's actually the norm. So City Council may approve a planning document or a planning item, but they weren't part of developing that planning document, where our DSD department would do it, working with the developer or things like that. So it's not unusual to vote on an item where you didn't participate. All you're really doing is getting information to make sure it's reliable and accurate. And that could either come from the individual saying, yeah, I reviewed it, I have nothing to add. It could come from staff indicating that they've reviewed it and it's consistent with the information they have as well in terms of what's going on. Recusal. Generally, there isn't, for a board of commission like this one, there isn't much to recuse yourself on. However, one of the things that you would recuse yourself on is if you have an economic interest in an item. When we started drafting our lobbying ordinance, we had a member that work for SDG&E as a lobbyist. And so they could recuse themselves from participation since it was an ordinance that would regulate his business and in particular his employment. So he recused himself. He had an economic interest, and then he had a common law bias interest. In terms of common law bias, that's basically where you have a bias that is so strong because you have a personal connection to the individual, the subject. So for example, we may have an item which involves a committee or a group you were part of, where you feel so strongly for that board or committee that you would vote for it, that you couldn't put that aside, where there would be a bias. You should recuse yourself. This issue might come up if we had a complaint involving one of our elected officials or a specified city official for the purposes of the code of ethics, where you were involved or were aware of facts. There might be a requirement that you recuse yourself because of that bias. So, if you have a concern, whether you believe there's an economic bias or a common law bias, please contact our office and we'll work with you. Economic biases, we're able to advise on from our side, but if it's complex and may implicate the Political Reform Act, which covers economic biases or items to recuse yourself on, we can get an opinion letter from the FPPC. We commonly do that for council members in terms of economic interests they may have on a subject. One thing about recusal, you should only recuse yourself when there's an actual conflict or an appearance of a conflict that's so great it taints the process. So for example, you may have said things about a person that's the subject of a complaint, whether it's on Facebook or social media, whether it's a newspaper article that makes it look like you have it out for that individual. It may require a recusal. Commonly, I've seen this more in terms of a land use issue, where, for example, we had a board and commission member from planning who lived in the community where they were going to build something. They had advocated against it, writing down, I think, certain type of newspaper articles, and encouraged people to come to the meeting to vote no against it or lodge their opposition to it. And then they were part of the decision-making process. Our advice was that they recuse themselves, and they did, because they were so vested in opposing something. You really can't make a decision whether it should be opposed or approved, because you've already committed yourself a lot to one side that would taint the process. But you need to take these very seriously and not recuse yourself just at the slightest drop of a hat, because at the end of the day, council members, they're elected to make a decision. Sometimes decisions are difficult and maybe controversial. And if you recuse yourself, you're kind of avoiding your duties to make these tough decisions. And same thing for you. You folks were placed on this board to make these tough decisions. And unless you have an actual either economic or common law bias, or there's the appearance that's so great that it taints the process, you should be participating. We'll work with you through that process to make a decision as to what's the best way to go. Economic biases are troublesome in that if you have an actual economic bias on something, it may subject you to not only just trouble generally, because you should have recused yourself. Economic conflicts may trigger the Political Reform Act or Government Code Section 1090 and subject you to criminal prosecution by other agencies. So that's really hard to you need to be right on that. And then the common law bias, there might not necessarily be personal criminal liability. There may be civil liability, and then the city may also face consequences through writ proceedings to undo the decision and attorney's fees and things like that. So these do have real world consequences if the decision isn't properly made. That's why we work with individuals to make sure we do the best we can to advise you on those things. When we do advise you, we're not advising you or actually any individual as to their individual liability. The perspective we take is we advise you to make sure that the city is able to participate. So And so our client isn't necessarily you, it's always the city, but we do advise you from the perspective of, we don't want you to have an economic bias that would impact the decision and then also impact you, a common law bias. We want to make sure that when we're advising you on that, it's looking at from the perspective so the decision isn't improper or problematic. Again, it has the side effect that it helps you as well. At the end of the day, we try to advise you. If it's something that's super controversial and complex, you can always get your own attorney on individual decisions on the item, but most of the time we're able to work through that process with you. Again, the Political Reform Act and the Chula Vista's Conflict of Interest Code in terms of economics says this: no person shall make or participate in making a governmental decision that he or she knows or has reason to know will have a reasonably foreseeable material effect on a material financial effect distinguishable from its effect on the public generally. Basically, you can't have a decision that's going to affect you in a way that benefits you that's different from anybody else. And so that's under the Political Reform Act. And a material financial effect basically goes to your income and your property holdings, stock holdings, and things like that. If you have questions about it, as I do our training on the Political Reform Act down the line, I'll tell you what the different material financial effects are that the Political Reform Act would look at. Again, you need to be aware of your business interests, real property interests, sources of income, including gifts, loans, travel payments, to ensure that you don't participate in a decision in which you have a conflict of interest. It's just being aware that, hey, this decision may affect my home, may affect whether I get paid. And the thing is, a lot of people think it's in terms of income and getting things that, oh, I'm getting more. It's also the opposite. Will this reduce my current income? So we look at it both ways in terms of, will it increase my property value or will it reduce it? Things like that. Generally, these really aren't items that you face. It's really items that the council members and other city officials may affect. But again, it's good to know in your situation. Again, this is more of a property interest conflict. One of the things is, if we're making a decision that impacts your real property of a distance of 500 to 1,000 feet, if it's within 500 feet, it's presumed to be a material effect, so you're conflicted out all the time. Then the 1,000 feet is that there's a rebuttable presumption that's there. Again, so we look at it 1,000 feet. If it's within 1,000 feet of real property, then there's probably going to be a conflict that's involved. Generally, the complaints we get aren't really site specific. Recusal. If you do recuse yourself, you have to state the reason for it. And if it's a Political Reform Act refusal, you have to state where the property is, and then recuse yourself on the matter. And then you have to leave the room while that item is being discussed. The only time you don't have to leave the room is if it's an item on the consent table. Again, you can't do anything to influence the decision. So again, if you recuse yourself, it's on the consent calendar. You can't roll your eyes. You can't, kind of hem and haw when that item's coming up. Anything that would influence a decision, you can't do. Member communications. In terms of communications, the city manager and city council, they're the individuals that speak for the city. Generally, boards and commissions do not. However, a lot of times when you're on a board and commission, you do make statements. And a lot of times it's for different boards and commissions, whether it's Human Relations Commission, the Planning Commission, Healthy Chula Vista, things where they want to get information out. There's two ways you can get information out. One is if you're doing it as a private individual. In both scenarios, whether you're doing it as a private individual or as an authorized representative of that board or commission, you have to make sure your statements are factual and truthful to the best of your ability. If you're doing it on by approval of the board or commission, then it has to be voted on. by the board and commission. So if you're going to make a statement, or the chair is going to make a statement on behalf of the board and commission, it has to be voted on that they're going to make a statement. And again, when a board or commission statements, they're basically stating, we're making a recommendation that council do this. They're not saying that it's the city's position that they do this. It's the board and commission's position that they do this. So for example, if we were to be asked about the proposed lobbying ordinance, we can say and have individuals say that the board is recommending that they pass this ordinance and give the reasons why. Again, it's not that the city should have it, it's our recommendation, because ultimately council will take the final action. If they're speaking without this authority from the board by a vote of the majority of the board, then they're speaking as individual citizens, and they should be clear that they're making that as an individual on an item that's being recommended to council by the board or commission. One thing that you folks should not discuss or make communications on is when we have an actual complaint and a hearing. The reason for that is these complaints that we hear are in the form of a quasi-judicial hearing, where we have due process that has to be afforded to the subject of the complaint, which means they have a right to a fair and impartial trier of fact, which would be you folks, the decision who make the people who listen to the facts and make a decision. It has to be fair and neutral and unbiased. And so if you're out there making statements about it, it does taint that process. So it's our advice that you not discuss a pending case before the board or commission, or a case that you believe may come before this board. That way the process is fair and doesn't distract from the actual issues that's going to be heard. It'll turn into a side issue. Well, did this commissioner say this? Did they have an agenda? How did they taint everybody else? And then it turns into, did they have off the record discussions? And suddenly it turns into, we got in a Public Records Act request for all communications between you, and it turns into a bigger deal. So it's better not to discuss it. And at the end of the day, you only want to hear evidence at the hearings, and only make your decisions based on that evidence that's presented at the hearing. Again, generally, if we're pursuing something as a recommendation to council, we'll get authority from the board and commission to speak on it. It could be based on assign it to the chair or vice chair, or it could be everybody can talk about it, but here are the talking points on that issue in terms of how far we're able to discuss it. Again, we're doing that process through, it's a recommendation. If you're doing it as an individual, you have to make sure that you're doing it as an individual. But you also have to be aware when you do things as an individual that you do represent the Board of Ethics, where your ethical standards have to be above reproach, since you are making these ethical judgments on other individuals. And so you have to be aware. That's why you really don't hear judges making statements on anything, even cases that they hear, cases that they get criticized. You really don't see them making endorsements of other candidates that are running for judges or political office. In fact, I think there was a change in the judicial canons that allows them to make statements on people that are running for judicial office, but that's like literally a law that was, or a rule that was passed last year. So it's generally the norm that judges don't make statements on things before them that's there. Again, you folks can make recommendations to council. That's how you get things to them. Part of your charge is to make recommendations to improve the code of ethics and your functions. You can make other recommendations to council in terms of ethical matters to help them improve. So the way you communicate to council is we do provide an annual report of your activities. You may make written reports to city council that can be submitted to them in terms of informational memorandum or written communication to the council agenda. You can also present ordinances or recommended ordinances for the consideration. There are times that you can also do joint meetings. So there's various ways we can communicate with city council that's there. Other boards and commissions on different issues have prepared letters that go to council that you folks vote on that's there. So there's different ways to communicate with council when we're doing things. Now, in terms of your duties with regard to the code of ethics and your Board of Ethics, the 2.28. The Code of Ethics is really the code by which city elected officials and higher city officials conduct themselves. It was divided into 3 different categories: aspirational goals, Board of Ethics aspirational goals, and specified prohibitions. And then the Board of Ethics basically has procedures in which they hear complaints for violations of the specified prohibitions. And it's important to know that you only hear specified prohibitions because of the aspirational goals and the Board of Ethics aspirational goals. So let me go through that quick. First, the Code of Ethics doesn't apply to every single employee. The Code of Ethics really applies to city officials, which is defined as the mayor, city council, the elected city attorney, department heads, the city manager, the assistant city manager, city clerk, board and commission members, and former city officials. So if you're the former mayor, former assistant city manager, those are included. It does not apply to deputy directors and regular line staff that does the work. It's for the higher up individuals. It doesn't mean that the other individuals don't have rules of ethics. They do, but for the Code of Ethics, it's specifically directed towards those individuals. The old version used to have only really the mayor and the city council. We expanded it to include other individuals. And so that's as far as we got was with those decision makers, which is really who we wanted to ensure that we have those individuals covered. It is not unusual for us to get complaints for non-city officials as defined in the Code of Ethics. So for example, when we have a complaint against a park and rec worker that isn't the director of the park and recs, or our park and recreation department, or the head librarian, those complaints would not meet the criteria for you to hear a complaint. And it's something I'll discuss down the line. So it applies to those individuals, and it's divided into 3 different components. The guiding principles for all city officials, that's the A section. Those are aspirational in nature. And when the revisions were written, there was 2 categories of things that we wanted to do. The first one was aspirational in nature, and the other one was specified prohibitions. The reason we did that was the old code had everything lumped into one. And the problem was due process. In order for you to defend against a charge, the charge has to be so specific that you're able to mount a defense against it. And due process requires that. And a lot of the things that were the old version of the Code of Ethics didn't meet the due process required of enough specificity. However, they were important that we needed to let people know when you're making a decision, you need to follow these aspirational guiding principles. Along the aspirational guidelines, we added ones for Board of Ethics members. Again, they were aspirational in nature to give a direction in terms of how you should conduct yourself and what type of how to conduct yourselves overall. C is the specified prohibitions. These were written in such a way that they're meant to be specific enough where it meets due process under the 14th Amendment, where a person has sufficient notice where they could defend themselves. And C is the ones that you folks would hear a complaint on and make a decision. And there's different steps that you would make a decision. I kind of want to share with you just a couple of the Code of Ethics that are out there in terms of the aspirational decisions as to why they're aspirational as opposed to a specific prohibition that would comply with the 14th Amendment due process clause. In it says one of the prohibitions, the guiding principles, as it says, it says city officials must protect and enhance the image and reputation of the city. Again, that doesn't give you enough direction as to what that means. What if you take a position on something that's controversial and people don't like it, and you get a whole bunch of complaints saying that person shouldn't have done that, they shouldn't be supporting this? Again, that's not what items would fall under that. So it wasn't specific enough. But again, people should be aware that in what they're doing, they're going to get judged by the public, and there's criticism that's going to be drawn, and you need to be aware that it may impact the way the city is perceived. But sometimes you have to make a decision that isn't proper, that isn't popular. You may take a position that is, difficult to make, but has to be discussed. And so we needed to make that a guiding a principle as opposed to a specified prohibition. Again, number one, it says city officials are agents of public purpose and hold office for the benefit of the public. As such, city officials have a duty to act in the best interest of the public. City officials must strive to protect the public's resources through diligent and judicious management. Again, it's a good goal to head towards, but a lot of times there's positions in terms of what is a best interest in the public. Is it something that's, are you going to build something here that in the short term it may not be in the best interest, but in the long term it is? It's again things that aren't specific enough, but I think the guiding principle tells the elected official or the public official or the city official, this is what you should be thinking about in making that decision. So am I making this decision to benefit the city and the public that they serve? Again, that's the purpose of these. The guiding principles for Board of Ethics members, they're really talking about in the B section is they need to be aware that people are going to judge you by how you conduct yourselves. And the way they judge you has an impact on the decisions you and the rest of the board makes. For example, under the additional guiding principles for Board of Ethics members, a Board of Ethics member should conduct their outside activities so as to minimize the risk of conflicts with their duties as a Board of Ethics member. Again, it doesn't specify what that outside activity may be that may impact us, but whatever outside activity you have, you should always be aware, I'm on the Board of Ethics. How's it going to reflect on me and the Board of Ethics as a whole? So that's what we want to do there. Again, the C1, B3, again, a Board of Ethics should perform their duties impartially, and it has additional language. Again, being aware that if you don't act impartial in different things, it may come back and impact the Board of Ethics as a whole. Same thing when you identify yourselves as a Board of Ethics member or you let people know, it puts you in a special position. We also wrote in, and this is true of all, whether you're a city official, meaning an elected official, or another board and commission member and you run for office, it is not improper for you to list the fact that you're a Board of Ethics member, a planning commission member, a civil service commission member, if you're running for office. And that's not unusual here or other jurisdictions where you say, I served on the planning commission. It lets the public know that you have experience in planning matters for the city, things like that. Same thing with civil service. If you're on that, it lets the public know and it gives them information that you've served on employment related matters. Same thing if you're on the Board of Ethics, that you've dealt with ethical issues and try to improve the city that way. Again, it's not improper for you to do that in terms of listing it as one of your activities. It is different though and improper if you say, I'm the mayor, and you go into a store and you say, hey, I'm the mayor, can I get a discount for that? Or can I get this for free? I'm on the Board of Ethics, can I get this? Same thing with the Planning Commission. I make planning decisions, I should be getting a discount on this because you may appear before one of us. Again, you could use your position generally letting people know what you do, but you can't use it for that personal gain. And when we talk, there's a specified prohibition that says use your position for personal gain. That's what we're talking about. If you list it when you're running for public office, it is not for personal gain. That's educating the public as to what your experience is. It's not personal gain in terms of how that section was written. Again, that's what we have. The specified prohibitions are the ones that you folks would take action on. And so the specified prohibitions are in subdivision C of 2.28050. Again, these are all in 050, and I've sent you copies of this. The first one is accept gifts, favors, or promises of future benefits which might compromise or tend to impair independence of judgment or action. This one is basically a quid pro quo. So if somebody gives you in exchange something for a vote or a favorable action on their behalf in terms of something you're able to do as a city official, whether it's the mayor, council, city attorney, city clerk, a board and commission member, it's quid pro quo where you're getting something in exchange for your position and vote. So it's quid pro quo. One of the areas that comes up with regard to this specified prohibition is campaign contributions. Under the FPPC regulation, a campaign contribution is not a gift. As a result, we do get complaints in the past where a council member votes on an item. They look at see in terms of who the council members' political contributions came from or campaign contributions came from, and they say, oh, the person that wanted this item passed gave a campaign contribution. That by itself does not violate this prohibition. That's been the ruling of the prior boards. That's our advice on these matters. In order for for a campaign contribution to cross the line, there has to be evidence of quid pro quo, which means there has to be additional evidence that it was done. There's an email or some document that says, I'm taking this campaign contribution because I'm going to vote for you on this. It literally has to be that type of smoking gun evidence on that, particularly because the FPPC says that a campaign contribution is not a gift. And so we have to be pretty consistent with that. If that were the case and somebody filed a complaint and there was evidence of quid pro quo, meaning somebody had an email saying, I'm going to vote for this, you're putting 200 in the bank or you're giving me a bag of money, things like that. If that is in fact true, our recommendation and one of the things that you're able to do when you get a complaint is we would refer that to the district attorney's office for an actual criminal investigation. Because realistically, the most sanction we would impose is a censure or recommendation for a sanction or removal from office through some process the council may or may not have. But we wouldn't be able to do a criminal matter. But case ourselves is something that should be referred to the district attorney's office. And that's where our advice would be if it's a quid pro quo situation. And then there's other rules that are there that are more specifically identified. Again, those are things that are there. So again, the guiding principles really broad in nature to guide you in terms of how to conduct yourselves and what to think about when you make a decision. And then the specified prohibitions. These are things you cannot do. If so, you'll take action, whether it's a referral to the district attorney's office, the FPPC, the Fair Practices Political Commission, or taking action yourselves in the matter. Again, that's the C section that's there. So how does this happen? That's the hearing process. The hearing process is in Municipal Code Section 2.28. I sent you that as part of our agenda packet. So the complaint comes in. There's a form that was written specifically to allow the individual to file a complaint and answer all the questions so the complaint form itself meets the minimum requirements to move the case forward. We get it. We number it with a certain format that we use. We provide notice to the complainant and the subject complaint that we received it, and then we set it with you folks for a prima facie review. Our office does not edit or filter a complaint that comes in. So it could be one that I read that has absolutely no merit. They're complaining about the San Diego mayor about things that they're doing. Clearly, we don't have jurisdiction over that. It's clearly not something that you folks are going to handle. I don't read it out. It will be given the number, and then it'll be processed for you to make that decision. We don't filter complaints. Whatever comes in, we number it and get it to you in terms of what's going forward. We'll set it for a prima facie review. That's really the first review. And what that is the process that we have is really threefold. And this is designed to kind of mimic a criminal and a civil case in terms of what's there, more of a criminal case. The first step in a criminal case is there's a complaint. that comes in, and the complaint's evaluated to see whether it gives enough notice and has enough facts where it could be defended against. And it actually states a violation of the law. The next step in a criminal case is in a felony, there's a preliminary hearing to see if there's a strong suspicion or probable cause that this case should continue to go forward. And then there's the trial, which would be the hearing in our case. So it follows that kind of format. So the first step is that prima facie review. That complaint comes in and we look at the four corners of the document. We don't take extra evidence. We don't hear witnesses. What we're looking at is, does this complaint, when you read it, does it meet the minimum requirements so the case go forward? And these are the minimum requirements. The complaint has to state that it was filed within 90 days of when the incident occurred. It has to be filed and signed under penalty of perjury. It has to name a person subject to the code. So it has to say, I'm complaining about the mayor, city council, city attorney, the city manager, a department head, or a board or commission member. If it lists somebody else other than that, then they haven't provided the required information. It has to contain a complete set of facts showing a violation of the specified prohibition. It has to provide a narrative or something. When you read it, it says on this date, I saw one of our planning commissioners was going to take this item up. I have this email and this other proof that they took money in exchange for a vote. It literally has to have that level of description and detail that there's a full set of facts. It can't be conclusionary in nature, meaning that it just says they did something bad. They have to be able to explain it and support it in terms of what's there. That way the person that's getting the complaint or is the subject of the complaint is able to defend it. So it has to say, have a date. That way they say on this date, I didn't do it because I wasn't even in the country. That way they're able to defend against it. So we're looking at that. The Board of Ethics hears only complaints regarding the specified prohibition. So whatever they're saying was done wrong has to be one of the specified prohibitions. So we'll look to make sure that's there. And again, like I said, it's just a review of the four corners of the complaint. And we really don't make a merit judgment. We assume all the facts in the complaint are true, but they just don't get there. So it says that, it involves another individual that isn't subject to it. It isn't signed under penalty of perjury. It isn't within 90 days. It doesn't give a factual description of that meets a specified prohibition. So for example, we can have something that says a council member X voted on this item and they had received a campaign contribution from them. That doesn't get you there because there's no evidence of quid pro quo. There is an exception though in terms of the campaign contributions for board and commission members. A board and commission member who ran for office, who got campaign contributions, can't vote on an item involving that campaign contributor. That's only for board and commission members. It doesn't apply to council members or other elected officials. It's just something that's within the FPPC regulations. Again, this document, you look at the four corners, you make sure it covers all that's required under the code, which is those elements that I read to you. We have the form that guides them through it. So literally it says in terms of I'm complaining about the following elected officials, and it lists all the ones that are subject to the code, and it lists other. And so they check mayor, council member, city manager, city attorney, and then if they don't check any of those, but they write, deputy director of animal control facility. Again, that's something that would meet the criteria, but at least we gave them a chance to explain it. It has a section where they provide a narrative where we tell them identify which campaign contribute, which specified prohibition was violated, and they check the box, and then they provide a description of how it was violated. Again, the form helps them guide through the process. Our office does review it and does provide a review and recommendation at this stage to see if there is a prima facie evidence to go forward on the matter. And then you folks decide whether there is or isn't. The next step after a prima facie review is there's a probable cause determination. That is, you're going to get some evidence of what happened. So you're reading the supporting documents if they have documents, emails, public records, other records that they have, a witness or two on the issue. And you're just listening there to see if there's enough evidence there that raises a strong suspicion that you're going to put the subject of the complaint through the process and make them go through the process. Again, the person who's complaining puts on the case. We don't do it for them. They put it on themselves, and they have to meet the standard of strong suspicion that's there. And so if they make it past that stage, the strong suspicion stage, then it gets set for a hearing. That is a more formal setting. The standard of proof is preponderance of the evidence. More likely than not that a violation did in fact occur. Again, the complainant bears the burden of proof, so they have to put on a case, give you evidence, swear witnesses in, provide documentary and other evidence for you to make a decision. Again, at each stage, we'll be helping you in terms of preparing a report or presentation as to whether or not they met their burden in terms of our advising you. Again, on these items, if we have a complaint or you think there may be a complaint coming, we ask that there be no discussions and no ex parte communication. So you're not talking to one side or the other outside of the individual. Again, because this is a full-blown hearing. You wouldn't want a judge talking to the prosecutor and not the defense attorney, or vice versa. You wouldn't want the judge talking to the defense attorney, but not the prosecutor. The judge talks to both. That way they both have a chance to present their side on whatever issue that's there. That's pretty much the process that goes there. We usually get, we've had several cases that in the last couple of years, they however have not made it past the prima facie review. We have one that had gone to hearing, but that was several years ago, quite a while ago. Again, there's really a desire and a goal of being fair, of listening to the evidence and making a decision only on the evidence that's there, and being, consistent with the law in terms of what's there. So that's pretty much the process. 2.01 is the code of ethics with guiding principles and specified prohibitions. 2.28 is the process that's there. There's a history that's there. Some of these things that I'm telling you about in terms of how we've advised and how the board has acted in the past, we have the ability to write opinion letters and provide them so there's a record rather than this kind of oral history of what we've done. I think in the next year or so, we'll probably start documenting some of these. That way we have a history of it and people know how you folks would be there, just like the courts. They issue opinions. There's published opinions. That way it guides the process and the understanding of each of the rules that are violated. Any questions on this? I know I've taken way longer than I should, but I just wanted to give you we could get super in detail, but then I probably got too much into the weeds. But any questions on what I've covered so far? No. Okay, hearing none, I'll go to the next thing real quick. Additional ethics laws that I expect to cover in the next year would be the Brown Act, which is the open meetings, public records law under the California Public Records Act, Government Code Section 1090, which is which is another form of financial interest that deals with contracts. It basically says government officials can't have a financial interest in a contract made by them. It's a very broad section and it's interpreted broadly. And then there's the Political Reform Act that says you can't have a financial interest in a decision made by you. And then Government Code Section 1099, which is incompatible offices. And then just some campaign finance laws, just so you're aware of it, because one of your duties is you do appoint our campaign contribution enforcement authority. That way you know what types of things they're doing. Even though you folks don't play a role in the enforcement of it, you do appoint the individuals that enforce it, that does that. Our office does not enforce the campaign contribution ordinance because we're subject to it. So I'll do some training on that down the line. So that concludes my presentation on this item. And unless you folks have any questions, I'll turn it back to Melanie, and then she can give it back to me for the next presentation.
Okay, thank you, Simone. So no questions? Thank you for the thorough explanation. That's very helpful from this point on.
Yeah, the goal really was to
now
give you enough where you can ask questions.
I'm sorry?
The goal really was, I know it's a lot of information right away. It's just, the goal really was, you heard it. It might sound familiar to you. So when we get to something like that, at least you'll have enough knowledge to ask a question that's more specific and we could address it. That's really the goal of these shorter presentations on it, and stuff.
Awesome. Thank you. Okay,
We're
I'll call for
2 minutes.
a 2-minute pause to allow public to submit any final comments on this item. Will the staff please display the public comment and start the timer? Thank you. Okay, the commenting period for this item is now closed. Is there any questions submitted?
No public comments received.
Do the board members have any comments or questions before we move on to the next item? Okay, nothing heard. Moving on to the item number 3. The next item on the agenda is presentation and discussion on the proposed lobbyist registration ordinance and the ex parte communication policy. Simone, do you have a presentation?
Enter again? I would hope so. So let me try to share my screen. Go to the next item. Okay, so this is an item that we've been working on for many years. I think we started in 2018. We made a lot of progress in that year. We met with different groups, whether it was I think we met with a building industry type group, because our DSD, our Development Services Department, has a working group with developers and other individuals to get their perspective on it. They had some comments. We met with the Chamber of Commerce and businesses and things like that, got their input, and we kind of started to make changes based on their edits. We're going to come back to you folks, and then combination of work and the pandemic has kind of slowed this down. So we want to try to get this rolling again, and so here we are. The work was done in conjunction. It was an item thought about from our office. The city attorney wanted to do something to improve and increase transparency. We worked with former board members Esquer and Jameson, and drafted the language that before we took it out, and we started talking about the edits that were made in response to what was in the lobbying ordinance. So the presentation really is what is being proposed and why, a summary of the key components, the next steps, and then questions and comments. Now, so what's being proposed? It's a lobbying ordinance. It's going to add chapter 2.55 to the Chula Vista Municipal Code, and it's going to require persons who are paid lobbyists to register as a lobbyist with the city, to identify who their clients are, and to regularly report their lobbying activities in the city. And then from that, they're going to report regarding their lobbying activities, and it's going to be maintained by the city clerk and made available to the public. And then the reports and activity are going to be reviewed by the Board of Ethics, and then the Board of Ethics is going to prepare an annual summary of what's going on in the city. I mean, there are certain things that would be put in the report to help the public really know who our elected officials and other specified individuals are meeting with that impact policy decisions. And so the reason we're doing it is a transparency. It's an important part of conducting the public's business, and it supports open government. We already have laws that do that. So for example, the Brown Act ensures that the public business is conducted in public via a timely noticed agenda, an opportunity to speak, and other protections. So we also have the California Public Records Act, which ensures public documents are available to the public subject to limited exceptions. So so our elected officials and other boards and commission members have to do their business out in public, and the public has to know what they're doing through that agenda, and will only address what's done in the agenda. And then the other thing is we have a Public Records Act, so any documents that we produce are public records, and there's limited exceptions where we don't produce them. The ordinance is going to further that continuum of public transparency, and that's going to provide, so we know that they're doing business out in public, that the documents being produced, the public has the right to look at. But the last part that we need in order to make sure that the public's completely aware of what's going on and there's transparency is that lobbyists, that way we know who's talking to who that's influencing the decisions that's going on. And really the goal is to really complete that process. City of San Diego has an ordinance that's a lobbyist registration ordinance. The county really has a couple of others, but there really aren't many out in the county. We would be probably the second largest jurisdiction to have one. And I think it's important given the different activities that are going on, whether it's the work on the Bayfront, the University Center, and development in general. So there's a lot of issues where people are wondering why decisions are made and how they're influenced. And the public gets to see it by the voting in public, by the documents that are produced, but they don't know who's talking to who. And I think this would complete that process. So the lobbyist registration ordinance really mirrors the city of San Diego's. We tweaked it to be unique to Chula Vista. Part of the reason we chose the city of San Diego's is because lobbyists don't necessarily only lobby in Chula Vista. They lobby in Chula Vista, San Diego, San Marcos, Oceanside, and the different cities. As a result, we know that a lot of them are familiar with the terms and what the requirements are, particularly with regard to the city of San Diego. So they know who they are as a lobbyist because we're using a similar definition. They know what type of activities are covered. They know who's covered that's there. So we want to create a system that was familiar to lobbyists or people subject to it. That way it's consistent countywide, particularly in terms of registration and reporting, in terms of annual reporting, activity reports and things like that. And then in terms of administration and enforcement. So we do copy the city of San Diego, but make tweaks that are unique to ourselves. So the key components are obviously definitions, registering, reporting, and administration of and enforcement. Now, this is what a lobbyist is defined as. In it, it's kind of hard to read, but the terms that are in italics are further defined. but this is what a lobbyist generally means. It means any person who is employed, retained, or otherwise engaged for compensation to lobby on behalf of another person or organization, any designated city official, either individually or collectively. So it's basically a person who does the following. It has to be a person that's compensated, which means money or any form of remuneration, which means it could be a trade for something, it could be cash, it could be any way you get money, Bitcoins, services. It's any form of compensation that's there. Discount to a restaurant, it's anything that's compensation. And they have to lobby, which means they're coming, it's a direct communication, meaning they're communicating through city council either directly, through emails, through social media, or things like that to influence a municipal decision. And there's municipal decisions defined in terms of particular things. A designated city official. And again, that's a defined term. So the covered person. So who would be a lobbyist? A professional lobbyist, somebody that we traditionally see before council. For example, SDG&E has paid employees that go and lobby. BIA representatives have people that go, which is the building industry folks that come and lobby for different decisions. A paid employee of a business whose duties involve lobbying for that business. So it could be an employee for a developer that's coming to advocate for a particular project that's hired for that purpose. An individual paid by an organization to advocate on their behalf. So there may be a nonprofit or other type of group that has somebody that's getting paid to advocate a particular position that's there. What isn't a lobbyist is a citizen advocating a matter of interest, but for no compensation. So if they don't meet all these requirements, so if they're not being compensated, they're not trying to influence a decision, or they're not talking to a designated official. If they fail to meet any of these, then they're not a lobbyist. So if anybody comes in and they're not getting paid to lobby, then they're not subject to the ordinance. A homeowner or business owner advocating for their own interest in their own business or home. So one of the things we found out is the city of Chula Vista, I think about 94% of our businesses in the city are small businesses. So it's usually a person that owns a business, may have 4 to 5 to 10 employees that's coming in on something. And it's the owner of the business. That's not who we're trying to cover. They could come in and lobby for their own business if they're the owner, or if it's somebody that's talking about their house in terms of, they're making these improvements, or they're doing something to a nearby park, getting rid of it, or making it smaller, and you want to talk about that park. If you're talking about it and it impacts your home or business, and you're the owner, then you're not a lobbyist. If you hire somebody to go do that for you, then you are a lobbyist. And then there's exceptions for technical experts that provide solely information in terms of parking studies, traffic flows. These are the technical experts. They're saying this is what the flow is. It supports this project or it doesn't. Again, those people wouldn't be subject to the ordinance. There's specified exclusions, which is listed in the ordinance itself, but these are generally the ones that come up. That's there. Direct communications is talking to a person directly, or in person or by phone, or now Zoom or other type of media. Again, by other electronic transmission, letters or notes, emails, text messages, direct messaging via social media, Facebook, Instagram. Skype is, I think, now old. It's probably WhatsApp and TikTok or things like that. So, or fax. People still do fax these days. So that's the communication that's covered. So it has to be somebody that's getting paid, that's engaged in a direct communication to lobby. And so lobbying is attempts to influence a municipal decision. And so municipal includes advocating for or against an ordinance, advocating for or against a development project, advocating for or against a city policy. They're specifically defined, but these are the general areas that's covered in terms of lobbying activities. Designated city officials. So you're a person, you're getting paid, you're going to lobby, which means you're going to advocate for an ordinance, a building project, or a policy. And this is the person you're going to lobby. The designated official that you're lobbying is the mayor or council member, their chiefs of staff, community liaisons, including policy aides. And what we want to do by that is a lot of times they may not have direct access to the council member or the mayor, but they have a chief of staff or community liaison that really acts for the mayor or council member in terms of getting them ready on issues. And so that chief of staff or community liaison does play an important policy role. So we wanted them included. Board and commission members. I see that happening a lot more in the planning commission as opposed to other boards and commissions. Maybe GMOC, maybe the Prop A and other commissions in terms of the different taxes that we have that are subject to oversight commissions. The city manager herself, the deputy and assistant city manager. Right now, the ordinance only lists assistant city manager because when it was written, that we only had an assistant city manager, but there are now deputy city managers, so we'll amend it to include them. Department directors and assistant department directors, again, these are people that not only make actual decisions, but make policy decisions that impact us. The city attorney's office, but this is unique. The city attorneys, in terms of lobbying our office to support a particular project or item, it does not include when somebody's coming to talk to us about a legal issue. So if somebody's telling us you shouldn't do this because it violates CEQA or it violates the Brown Act or violates some legal principle, where we need to talk to them in order to avert any liability for the city, or to discuss a settlement of a case or a particular matter, those type of issues they can still talk to us about. And that's to the benefit of the city as the whole. And then the zoning administrator on specified matters. The zoning administrator acts like the planning commission on particular smaller items. The planning commission takes certain items, and then the zoning administrator is able to take other items. So it's really those key areas, the major policymakers that's being lobbied, that sets the direction as a whole for everybody else that's there. So that's the designated city officials. There are activities that are excluded, and these activities are also excluded under the San Diego version, and some of which we added for ours. Communications with other government officials. So if we're talking to a SANDAG representative, another mayor, another council members, that doesn't qualify as lobbying. Communications with the news media doesn't qualify. Questions or inquiries as part of a response to or processing in an RFP or RFQ. An MOU and MMBA requirements with union activities. So if we're talking to one of our bar units, whether it's IFF, mid managers, SEIU, those activities are not considered lobbying activities. A part of the reason for that is we felt that in order to make it counted as a lobbying activity, it impacts state law too much, and might not be proper given the MMBA. So we wanted to exclude that, so we continue our discussion, and the representative is required by statute. So I think legally we wouldn't be able to do it. Legal and discussions increase, again, that's for the city attorney's office. Discussion with lower level staff employees related to project processing. So if they're talking to one of our planners about, here's a plan that we've submitted, you said that it's deficient in this way, can you explain what that means, or what we have to be compliant, or we're compliant because of that. Those are normal discussions that occur. Discussions with the DSD director or the assistant DSD director on the implementation or interpretation of land use approvals, except for certain type of land use approvals that deal with general plan amendments, specific plan amendments, the higher end type of planning decisions that not only impact a particular project but impact all other projects. So we're pretty there, specific there. De minimis contacts. This came up as a result of our discussions with different groups, because we wanted them to report all their contacts. And they said, well, what if I'm in the elevator with one of the council members and I go, hey, my item's up coming on Wednesday. Are you guys ready to go on it? He goes, yeah. And that's all they say. It's just, there isn't any advocating for or against the project. It's just letting them know, hey, it's coming up. And so we defined a de minimis contact, which is an unplanned contact with the designated city official that lasts less than a minute and does not advocate for or against a particular item that's appeared before council. Again, it's coming up when you see somebody, and so they wouldn't have to report that. If they met with them, of course, that would be a whole different thing. Again, the technical experts. And then the other part is what isn't included is if you're a lobbyist and you get paid and you only appear on an item at a public meeting. So if you only come to a city council meeting, you do not have to register as a lobbyist because everybody has the right to appear. It's when you're out meeting, contacting these city officials outside of that public realm, that's what we want to cover. Realistically, people who are regularly employed as a lobbyist isn't really going to be exempt because they're going to be meeting with people both at the hearing and then prior to the hearing itself. So it's really going to be the rare case that we see that. But if you're always conducting your business in the public, there really isn't any point to register you and require your activities because it's already on the record. And so basically, the lobbyist, any person for compensation who directly communicates with communicates with a designated city official to influence a decision, that's the lobbyist that's there. And so what do they have to do? They have to register. There's initial registration. They have to register every year. They have to provide specified information, and they have to pay a fee that's going to be set through a public process to cover the cost of administering this program in it. They have to report their activities on a quarterly basis, who they lobbied, a short description of the subject of 20 words or so. The reason we chose 20 words is because under the Brown Act, if we have an item on the agenda, that the language under the Brown Act says they want a description that's generally 20 words. And so that's where we picked it. It wasn't a random number. It was trying to be consistent with other laws that are out there. So we just want a short description that provides enough information what they were talking about. And then time spent discussing the item they lobbied on, and it's reported in increments. The city of San Diego actually requires daily not daily reports. They have to document their daily meetings and how long they met. So for example, the way they report is on January 3rd, I met with this council member for 20 minutes on this issue. We're going to have on this date, I met with the council member, and it could be multiple dates, and the overall amount of time I spent talking with them. So it'd be on these dates, I met with council member X, we discussed this issue, and we spent greater than 10 hours discussing it. And the reason we wanted to do that, and one of the concerns was from the different groups that were involved, was they didn't want there to be an aha moment that their records or other records show that, oh, the record shows they met with you for 45 minutes as opposed to the half hour you set. And so really it wasn't the point to get somebody in trouble because they're 15 minutes off. What we want to know is you met on these dates, and this is generally how much time you met. It's not really to capture somebody for the aha. We want people to know you're talking about somebody for 10 hours. And the reason that's kind of important is if you're talking about somebody to 10 hours, the public's going to go, that's a lot of time that you're devoting to a subject. And we took this from really the FPPC Form 700 when it talks about when you identify your economic interest. It's and I think you folks, and I know I have filled out the Form 700, and it says I have an interest in this property, and here's the value, and it gives like the value in different ranges. So we mimic that language there. We also can go back to provide the date and time and do it like the city of San Diego. But you know, I think this is a good compromise that will kind of address the concern that the lobbyists and the different industries had, and it meets our needs in terms of the range. The numbers in terms of greater than 10 hours could be changed because, you know, if it suddenly turns into I met with them for 100 hours, that's greater than 10, but that, 11 and 100 is a big difference. So that's a number we could work on in terms of what's there. But we felt that this was kind of a good way to compromise where we can and meet the needs of the ordinance. So we know who they're talking about, the dates they met, and the amount of time they're spending on this subject. And it doesn't turn into kind of administrative nightmare for either side, because people forget things in terms of how long they were there, or they may round up or they may round down. 35 minutes, is that 45 minutes or is that 30? And then you get into different rules of what that means. In an ideal world, they write 35 minutes, but sometimes they don't. So that was part of the reporting requirement. Lobbyists, they're required to disclose that they are lobbyists when they meet with the city official. And the reason for that is because we want to make sure that the council members know that they're being lobbied, and the different boards and commissions, and also because we're going to have an attended ex parte communication policy that I'll briefly discuss. And it won't be as long as this. And then they have to disclose when they come to a public meeting that they've met with one of the public officials 30 days, for the time period 30 days before that meeting. So if the meeting's on January 30th, they have to report at that public hearing that they've met with the council member within those 30 days. And one of the concerns they had is some said, I'm a lobbyist, I'm proud to be a lobbyist, and I'll tell people I'm a lobbyist. Others said, I don't want to say I'm a lobbyist because that has negative connotations. So they don't have to identify themselves as a lobbyist, but we did have proposed language in terms of what we would want them to do. And let me get that real quick. And that's found in 255070. And so the language we're proposing is that, for example, the above disclosure shall be made as follows. John Doe appearing on behalf of Jane Doe on item X, and for the record, I've contacted council members X, Y, and Z on this matter within the last 30 days before this meeting. Again, they don't have to say they're lobbyists, but they have to say who they are, who they're representing, and then who they contacted within the last 30 days. That way, the public knows that there's been discussion on the item. Administration, the city clerk is really going to take the bulk of these administrative tasks. They're going to prepare the forms and reports. We already have a computer page that we use where people can report, and we've run it to see if it'll work. I think there's some tweaks that need to be made for it, but at least we have something that will be up and running. They'll accept the reports. They can issue fines if the reports are late. They may waive late fees if there's good cause to do so. And literally it's pretty strict and defines what would be considered a good cause. They have to, and then the city clerk will provide a yearly report to council on registrations, complaints, and recommendations to improve the ordinance. Just like you folks will, I think the city clerk should play a role. They also may provide courtesy notices that the registration is required or something's missing, but they're not required to do so because ultimately the lobbyist has to be responsible for ensuring their obligations. And then they may refer complaints to the enforcement authority if they see a late fee, a failure to report, or they get a complaint from the public that something's improper. The complaint is going to be done by an enforcement authority, kind of the same way we do our campaign contribution enforcement. So we get a special attorney, a special counsel that has the ability to prosecute these cases on the civil side if it's a criminal violation. So it's going to come into the enforcement authority. They're going to look at it and see whether or not it should be pursued civilly or criminally. If it's criminally, it'll get referred to the DA's office. If they want to pursue it civilly, there's going to be two enforcement authorities. The first enforcement authority is going to take the complaint, see if it's a criminal or civil matter. They're also going to see if the case should be pursued, meaning that there is a violation, and make a probable cause determination. And then they're going to turn it over. If they find that there is a probable cause that the case should go forward, then they're going to turn it over to another attorney that'll handle the prosecution, who will review it for probable cause and then forward and then continue the process forward. The reason we did that was if we have a special attorney prosecuting the cases and they know that they'll make more money by prosecuting every case they get, that creates a built-in bias to prosecute as many cases as they can. But if the initial enforcement authority just knows, I got to decide whether it should go forward, but they don't get any money going forward, it reduces that kind of conflict of interest or perceived conflict of interest of a financial interest. Because, you know, once they make their determination, they're done. They have no more interest in the matter. The second attorney at that point will pursue the case going forward. The reason we have the other attorney review it to make sure there's probable cause is because every attorney that pursues the matter has to personally make sure that the case isn't frivolous. And so they have that obligation to do so as well. So the process is a complaint's received by the city clerk. They determine if it's complete, meaning it has all the required information, and then they refer to the enforcement authority. They review the complaint, determines if there's probable cause, whether it's civil or administrative, and then they prosecute, make the referral or assign it to the next city attorney, enforcement authority. Again, they could do it civilly, they could do it administratively. Civilly let me hold on for a second. Actually, I'll go for it. Hold on. My dog is barking. Okay, I'm back. I'm sorry about that. Like everybody else, my kids are too old to interrupt me because they know to stay away, and my dog doesn't though. So he had something stuck underneath, and I put him out of the room. So again, they'll make the referral civilly. That's to pursue larger fines and can also get injunctive relief and any other kind of civil remedy that's available. The administrative, they can issue fines and do an administrative hearing that's there. Again, it's within their discretion. If there's criminal prosecution, it goes to the DA's office. The enforcement authority may also refer to the prosecuting attorney, whether it's the FPPC, the Attorney General, or the DA's office if there's other violations of the law found. For the Board of Ethics, the city clerk will forward to the Board of Ethics all lobbyist registration and quarterly reports, as well as complaints and things like that. And so what we're hoping is that the Board of Ethics would kind of analyze the type of lobbying activity that occurred. They would give the number of lobbyists that we have in the city, the types of activities they're engaged in, the number of hours that they spend, the type of issues that they're looking at. Preferably, we would identify, and rank them in terms of what's out there. That way, the public is aware of what the issues are and who's influencing these issues or lobbying for these issues. From time to time, as you folks go forward, we'll make recommendations to improve the ordinance or make changes to it, which isn't unusual because as we go through, we'll discover areas that are weak or need addressing that we would go ahead and tidy up. Areas that are cumbersome and really don't serve a purpose, we would ratchet those down and make it work for everybody. Because at the end of the day, the goal is really that public transparency. The Brown Act with the public records, the Brown Act with public participation in these open meetings where decisions are made openly, public records, California Public Records Act, we have those documents that people can see that's being prepared on issues and city activities. And then this component really lets who's talking to who that's influencing decisions. And it's really a tool to be used, again, for the public to see what's going on and who's doing it. That way they can get information on who the lobbyists are, whether they're making campaign contributions, just all the litany of issues that are out there. That way we sunshine the whole process, and the public has confidence in terms of decisions are being made. There are no backroom deals, and that the public's aware of everything that's considered in making a decision. That way they truly know that the decisions are made looking for the city and the public's best interest. So that's pretty much the ordinance. Again, it defines who a lobbyist is, the reporting requirements, the city clerk administering it, and then the role that you folks play in the matter. There's additional things we can do to expand it. In terms of administrative hearings, we can have you folks be the administrative body that hears the hearing and do the fines. So there's a little bit more roles you could play. Administratively, the way we do it right now on different administrative hearings, we usually have a department director or an assistant director that has some expertise in the area. Here are administrative hearings in cases. We've also have a pool that we could send those cases out to have a hearing officer, but it's something that we could do internally too. For example, civil service does administrative hearings regarding employee disciplinary matters and things like that. So there's additional roles we could play that's there in terms of adding to it. The next steps that we're looking at is having an ex parte communication policy. And what that's about is, right now we're talking about who the lobbyists are. They're talking to the elected officials and other individuals. The other component is, what do the elected officials and other city officials, what do they have to report? And what do they have, and what are the prohibitions and what are they allowed to do? Generally, most of the ex parte policies that I've seen involve quasi-judicial hearings. So for example, they involve, so for example, if we have a planning decision and there's going to be a hearing on a planning, so are we going to approve the building of this add-on to a house? And in it, it provides due process rules. So for example, you're going to have two parties to the matter, the person that wants the house built and the people that are against it. And in it, it provides ex parte communications. So for example, it says you shouldn't talk to either party. Any discussion should be done at the hearing itself. In terms of evidence that you get, it should all be done at the hearing. If they give you evidence separately, to provide it to the body as a whole, to generally not go out to the scene to look at that house. So there's rules like that are generally done, which I think our ex parte policy would have. But the other component that I really haven't seen out there that we're going to have to work on is, what do we want the other city officials to report? The number of meetings that they have, or do we want them to disclose items in terms at a hearing or at a council meeting or things like that? So those are areas that we're going to have to work on. Of course, we would solicit input and work with you folks to develop one. So once we've kind of wrapped up the language that we would like on the lobbying ordinance, and then have the ex parte communication policy as well, we would, meaning with you folks, we would then solicit input from other interested groups, kind of go back there, see what their issues are. We can either, understand their issues, try to see where we can address their issues, or be able to explain why we weren't able to address those issues. And then the ultimate goal is to present the ordinance to City Council for its consideration and input. That's something that I believe we would do jointly with you folks or your representatives from the board from the Board of Ethics. We did that when we created the Code of Ethics and made the revisions. And then we would create the forms and take the necessary steps to implement the ordinance. The ordinance itself has some language in terms of how long we would be a grace period that would be in effect to get us up and running once council approves it. So that's pretty much the next steps in terms of what's going on. Do you folks have any questions?
Okay, if there's no questions from the board, from board members, Thank you, Simone, for that presentation. Sure, nobody has any questions?
Yeah, it's a lot. We did send you a copy of it as well. The next item on the agenda we'll discuss in terms of how to get into the weeds with you folks and be able to make this a working document that we would take to council. Thank you.
All right. Thank you. All right, we'll go ahead and call for the 2-minute pause to allow the public to submit any final comments on this item. Thank you. Okay, were there any comments submitted?
No comments other than the test comment I submitted just to make sure we were up and running.
Thank you. Do any board members have any comments or questions before we proceed to the next agenda item? Okay, I see a lot of shaking heads, so we'll continue on to item number 4. The next item on the agenda is discussion and action to establish, including appointment of members to Board of Ethics Ad Hoc Committee to assist in proposed lobbyist registration ordinance and ex parte communication policy. Simone, over to you.
Yeah. To make sure I'm not, okay, mute. One, I want to thank you folks. I see it's 7 o'clock, so you've been very patient and listening on kind of detailed in the weed stuff. So I very much appreciate your patience on this. So basically, what I like to do is we had a working group of 2 to 3 Board of Ethics members to get this off the ground. We've done a good amount of work, but we're kind of going to review what we have and then go back to the different groups and get this item going forward. And then we also need help in terms of the ex parte communication policy to draft language on that. We have an initial draft which only covers the quasi-judicial component that we've written, and then it has kind of placeholders for issues of expanding that. But we don't have any language that's there yet. So what I would ask, if you folks would like, is to have an ad hoc committee of less than a quorum, 2 to 3 members from you folks that would be available to meet, whether it's via Skype or email exchanges, to review the language in it and provide input. And then whether it's all of you, or all of the members of the ad hoc committee, or one, go with us when we go meet with these stakeholders. For a variety of reasons, I think it's important for you folks to see who these individuals are, what issues they have. That way we're able to address them and understand what their concerns are. And not just our office, but the Board of Ethics as well, to understand where they're coming from. on it as well. And so and plus, since you're helping with the language, we could explain to them what our issues and concerns were as well. So, so what I'm asking for is whether there'd be 2 or 3 interested individuals to meet as needed to kind of get this item continuing forward. I'd anticipate maybe meeting once every other month. It may be more as we get closer to things and go forward from there on this item. So that's what we're asking for on it. That way, and whatever action the ad hoc committees, we would of course come back to the full board for their recommendation of the product as a whole after we've kind of gone through our internal discussions, meeting with the stakeholders, and then have you folks adopt the final version to recommend to council as well. That way, there's full board participation on the item.
We'll open it up to volunteers. Anybody like to do this?
I'd be interested in serving on this ad hoc committee. I think I've mentioned before in the past that I've been a lobbyist before and had to do these different disclosures and lobbyist reports with the County of San Diego, the city. So I'm familiar on that end, but also given my experience as a public official working for Sandag, we have to kind of see both sides there. So I'd be happy to toss my hat in the ring. The only question that I do have for Simone is, you mentioned earlier about our new board member and terms and everything. I just checked the website, and my term, it looks like, is up this June. So do you foresee that being an issue if I serve on this committee?
It's the first term that's expiring. Is that correct?
Correct. I think I took over somebody else's term.
Yeah. Well, you still have the ability to get reappointed for a second term. I don't see the reason why they would not reappoint you. So I don't see an issue, particularly given your expertise in this matter, or at least your experience would be helpful. And so I would anticipate having you at least for the next term.
Okay. Perfect. Thank you.
Okay, thank you, Mr. Welling. Anybody else? 1 or 2 more volunteers?
This is Carla Chen. I'm also interested.
Okay. So that's 2. Anybody else? Simone, does 2 is 2 good enough, or do you want 3?
No, two's fine. One of the things I'll do is I can inquire of Mr. Saltzman if he would be interested, and if he's individually interested, I'll put it on the agenda.
Okay. Should we make a motion for that now?
Yes, please.
So I guess I'll make a motion to approve Alex Welling and Carla Chin as the 2 ad hoc to the ad hoc committee for the lobbyist registration ordinance.
I'll second that motion.
And then we should have our 2 minutes before you take your vote.
Okay. So please call a 2-minute timer. Thank you. Okay, 2 minutes is up. Were there any comments submitted?
No comments received.
Okay. Do any board members have any comments or questions before we proceed for the vote? Okay, nothing heard.
Okay, I will now request each member's vote by roll call. Barragan,
Yes, I approve.
Chin,
Yes.
Teal,
Yes.
Torres,
Aye.
Welling,
Aye.
Guerrero,
Aye.
and we'll note for the record, Member Salzman's absence.
Great, thank you very much.
Okay, thank you. And that concludes the last item on the agenda. We'll go on to staff comments.
Just real quick, Happy New Year. I'm glad to see everybody. I appreciate all your work and hopefully we'll at a minimum meet quarterly. And so this could be our quarterly meeting, but again, I want to go through the different list of trainings. I won't put 2 at a time because that eats up too much time. Like today, it took longer than I anticipated. So the next training that I intend to put on would be the Brown Act, which deals with open meetings. The interesting thing is effective January 1st, they made changes to the Brown Act that talks about social media. The good thing is the changes they made to the social media has been consistent with the advice we've been giving other board and commission members and city council on that issue. So we've done pretty well, but now it's formalized. So the next training will be Brown Act. It'll be a little bit quicker than it was today, but I'd like to go through the list of those items.
Okay,
And it's good to see everybody.
thank you, Simone. And yes, Happy New Year to everybody. I don't have any comments. Just thank everybody for being able to attend, and Simone for the great presentations. I know you feel they're long, but they're very informative, so greatly appreciate it. And also sending out the handouts. Those are good references for other times. So thank you and your staff for putting that together. Board members, I'll open up to you all. Does anybody have any comments?
I do. Can we not have a meeting on February 17th? It's my 40th birthday, so I don't want to attend. That's my request.
Mr. Chair, I can offer you an option. We can either have a special meeting on the 24th, which would be the following week, or we can wait till March.
You know what? We'll see if it's if we even have one, number one. But yeah, 24th would be fine if it's okay with everybody else. I see shaking heads. Anybody? Well, there's people I can't see, but it's standard to push it to the 24th, and if not, for the following month in March. Thank you, Simone.
Thank you.
Happy early birthday, Ms. Teal.
Thank you.
Any other comments?
This is Barragan. I did have a question. I think back in September there was government and ethics training. I believe that's the training that's required. I don't know if it's annually or every other year. I wanted to know if there was a way to fulfill a requirement coming up, another opportunity.
Yeah, the training is AB 1234. It is required. I think it's required it's required within a specified time period when you first come on, and then it's required every other year. There is another way you could do it if you weren't unable to make that. There's I think either an FPPC or an Attorney General link to the training where you can do it and get a certificate. Usually I do both. I attend the training, the live training, and then do the AG one to make sure we're not missing anything they have. What I'll go ahead and do is, Joyce, if you could, I'll send you the link, and if you could send it out to all the board and commission members, that way you folks always kind of have it to make sure that you complete the training.
I'd be happy to do so. Thanks.
Yeah. And another kind of quick reminder, even though it's not April yet, please remember April 1st is our Form 700s that are due. It's something that we're required to do, and I know it's January and April's quite a ways away, but it's always good to be thinking ahead.
Thank you. Any other board members have anything? All right, so tentatively, we're scheduled for the 24th of February, same time, 5:15. And it is now 7:20, and I'm adjourning this meeting to the next regular meeting, as I mentioned, February 24th, and according to the script, the City Hall Building A Executive Conference Room, but more likely it'll be via virtual platform. If there's nothing else, thank you all for tonight. And again, thank you to our staff, Simone and yourself, for putting this together.
Great. Thank you very much. Good to see everybody. Take care. Thank you. Thank you, Mr. Chair.
Going offline.